and it's usually considered contested. They can contest a will. There are specific grounds. The most common grounds would be mental incapacity or undue influence. So if there's a concern, hypothetically you had two children, one was not named in the will for some reason, the other one was given everything. The one that was not named, if they felt there was some form of undue influence or mental incapacity, they might challenge or contest the will.
So anybody can contest it. It could be a friend, it could be an acquaintance, but I guess the burden of proof would have to be on them?
Not just anybody can contest it.
Oh, is that right?
Generally, it needs to be a person who would have been an interested party in your estate. Perhaps a person who would have been an heir or beneficiary, a child, a spouse. We see this a lot when you have elderly clients or elderly people, and perhaps they have children who are estranged or who lived far away and who suddenly came back into the picture during the last few years of mom or dad's life and sort of excluded that parent from the
Right.
other, or isolated that parent from the other children.
Right.
So no, not just anybody can challenge a will. It's generally going to be a family member who would have ordinarily had some interest in the estate.
Well, let's say you had an elderly person who was ill and needed some caretaking, and the only person who was willing to be that caretaker would be a neighbor, or would be a friend that would come in. And they were there for a year straight, every day, taking care of this person, helping out, getting their groceries. Would they be entitled? Would they be a person who can challenge this will?
Not really. If they had been, let's say they'd been named in a previous will, and a new will had been made under sketchy circumstances or circumstances that might have indicated there was some sort of coercion or undue influence, then in a situation like that, that excluded neighbor might have grounds to file a will contest.
So there has to be some kind of a blood relationship, I would say, or some kind of a family relationship.
There has to be some connection there that would give rise to that person having an interest in the estate or previously having had an interest in the estate.
Right.
Otherwise, I suppose we could all go out and challenge.
Well, I was his buddy. Yeah.
And so there really has to be some logical connection there, or perhaps that person would have been what's called a natural object of their bounty. In other words, a child or other family member that might have had an interest in the estate.
A natural object of your bounty.
That is a very specific.
You attorneys just make this stuff up.
Law that when we're looking at a person's mental capacity to make a will, one of the things that we are looking for in trying to determine whether that person has mental capacity is, do they know the, quote, natural objects of their bounty?
Okay.
It's funny how it just starts to roll out.
It does.
It rolls off your tongue.
Kind of scaring me a little bit. Okay, what about taxes? Are taxes due on estates in North Carolina?
I'm actually going to let Amy handle this one.
Fun. Well, it really depends on the size of your estate. And if you've been keeping up with the news over the past few years, then you'll know that we've had an increasing exclusion amount under the federal estate tax laws. Currently, as of January 1st of this year, the magic number is $3.5 million. If an individual person's estate does not exceed $3.5 million, then they are not going to be liable for federal estate tax.
That's good.
North Carolina has a tax scheme for estate taxes that allows you to not pay estate taxes unless your estate is subject to federal estate taxes. So again, the magic number, at least for 2009, is $3.5 million. In 2010, under the estate tax laws as they currently stand, there's a repeal of the estate tax, meaning that you wouldn't pay estate tax regardless of the size of your estate. There are a lot of what ifs and a lot of unknowns, and so we don't really know if the estate tax laws will remain as they're written. And even if they do, what will happen after 2010? Again, the laws as they currently are written would have us going back to the $1 million exclusion amount. Will it stay the same? We really can't answer that.
So estate planning obviously is very, very, very important. And it has to be adjusted apparently depending on how the law is written or rewritten.
Exactly. You need to have a plan that either keeps up with the changes or at least builds in some flexibility to cover those changes and contingencies.
And legislators are the one who actually change these things.
Yes.
And most of them are attorneys.
Job security.
Job security.
In uncertain
We had this conversation with accountants last show. But anyway, I digress.
Well, and it's important to bear in mind too that what all your assets are going to include that counts towards that amount that Amy's talking about, that $3.5 million. A lot of people don't realize that that's going to include things like your life insurance.
Oh, it's all the assets.
It's all your assets.
All the assets. So that's important. That $3.5 million actually is not really a high number for a lot of people.
That's true.
Yeah. Erika, what is a trust? I've heard about them. Are they necessary? What is their purpose?
Sure. Simple way to describe a trust is basically that a third party is holding funds or assets for the benefit of a named beneficiary. Are they important? They certainly can be. It really depends on your individual estate planning needs as to whether or not you would benefit from a trust.
So it depends on the size, I guess, of the assets that you have.
Not necessarily. There are things like minor trusts that are going to be a benefit to you if you have a minor child and want to make sure that you want to plan for that child.
Who would be a trustee, I guess it would be?
Sure,
who would be a trustee?
That's the correct term, and it's whom you choose. Who would you choose to name as the trustee? If you don't name someone, the court certainly will do that for you, but most people do prefer to name their own trustee.
If a trustee is named by the courts, obviously there's a fee that's going to be paid to
Absolutely.
the trustee.
And just like the executor, your trustee can and is entitled to a fee whether it's named by you or by the court.
And what does a trustee actually have to do? Are they required to keep records of how the money is spent?
Yes, the trustee, the whole goal is that the trustee is going to maintain and manage those assets for the benefit of that named party, whomever that might be. If it's a child, then for that child, that they might be entitled to use of those funds for health, education, welfare support, maintenance, some of the basic needs. But they're not going to necessarily be able to receive the actual bulk of that trust until such time as they've reached perhaps a certain age, whatever you've decided is appropriate based on how we draft that trust.
And the terms can be drafted in such a way with a minor child, or even when he reaches majority,
Sure.
they can get a certain amount every year, or upon marriage. If you see these movies, and you're only going to get my money if you get married, is that right?
There are various ways to draft
any
it.
condition you want to put in there as the trust writer, you can do.
Well, we have to be careful when we say any condition. There are certain things that are against public policy. We certainly can't draft that into it. But there, for most things, most of your examples there, such as various ages, things like that, certainly we can.
What is a living trust?
Living trust is a trust you do while, believe it, you're alive. And that's something that you might want to make sure that you have if, for instance, you need to transfer assets into that now, where you don't want to have those assets pass after you've passed away. Some of the benefits of a trust are that it's not going to be made public. Where a will, once you've passed,
that's very important.
right,
Sure.
once you've passed on and that will is brought to the courthouse and administered as part of the estate, that's part of a public record. People can see that. So if you are someone that, for whatever reason, you feel you need to transfer property or assets in such a way as you want to keep that private, then a trust is a very good way to do that.
Anything can be put in a trust. Real property, stocks, cash, or accounts, anything at all. I mean, vehicles,
Assets.
some people have a large...
Most anything.
Most anything.
Certain things can't be titled in the name of a trust, such as qualified retirement or pension plans, things that are tax deferred, like your 401k or IRA assets.
Why is that?
Those really can't be titled in the name of the trust because that can be deemed a distribution that's going to trigger all sorts of income tax liabilities. Not the end of the world. Those assets typically have beneficiary designations associated with them, so that money's going to the beneficiary that you've named. And so I don't, for the most part, consider that to be a huge problem if I'm working with a client that wants to put assets into a revocable living trust.
Well, we are out of time. This has been so interesting. We may have to have you come back because I know we're going to get some questions from our viewers. And I just want to thank Erika Erlenbach and Amy Isaacs for coming in today from the McIntosh Law Firm. And I thank you very much for this opportunity to speak with you. We may have to have you back for some more information.
Thank
you
you
very much.
Thank you.
We appreciate it.